doesn't help them at all. What the judge was doing in that passage was merely recording the fact that at that jurisdiction hearing, the defendants were not running certain arguments. And so the mere fact that the defendants were not running certain arguments doesn't prove the converse. We say that even if the first defendant was acting as the agent for the second defendant for certain purposes, that's not enough to amount to a finding of a breach of the prohibition. And you've got all the points that we made before. If you look at what Mr. Nair was doing, he was not running the accounts, he wasn't running the investments, he wasn't going out and buying the instruments, he wasn't granting credit. And by and large, he was acting as a conduit between the two parties. Moving on, the specified activities. My learned friend didn't correctly state my position in relation to all the four activities in a number of respects. I don't need to quibble here because I'm sure you've got my points in mind, and as I understand it, you will have the transcript of my submissions when it comes to writing your judgment. But before dealing with each specified activity, I'd like to stress you have to focus on what was the position at the time of each of the three transactions. You shouldn't really be looking at everything after February 2008 when the last transaction was concluded. But when you look at Appendix 1, and a large number of the examples that my learned friend has relied upon, including the margin calls at the end of 2008, post-date the third set of transactions. Going through the four, dealing in investments as principal. The advantages of having an oral hearing in a case like this with such a large volume of material is that at the end of the day, you can boil down and look at what the real issues are. Mr. Hill accepted that the most important of the four alleged activities for the purposes of your decision is, were we dealing in investments as principal within the jurisdiction? And if you don't find we were dealing as principal, then his case really does have a great deal of difficulty, because it is this head which ties in with the claim for compensation, which is based on, in effect, setting aside the actual purchases of the note. And the points made by my learned friend in Appendix 3 of his skeleton argument, we say confuse arranging, which is quite a separate activity, and he's treating the acts of arranging by the first defendant as the dealing in itself by my clients. What I would like to do is just to take you back to General 2.7.1, which is in G3, tab 92 at 5638. It's, if I can just, it's page 5638, 2.71, and it's absolutely critical that the court gets this right. Dealing in investments means the principal buying, selling, subscribing for, or underwriting any investment as principal. So it's the principal, that's our clients, actually buying. It's not anyone else buying, it's the principal buying, selling, etc. And as I said in my opening, there are two ways of reading this provision. My primary case, as I'm sure you appreciate, is that dealing in investments is the actual transactions. When you go out to deal, that's the actual purchase and sale of the structured notes. And if I'm right on that, then they fail on that, because it's quite clear that all the dealing in that sense took place in Switzerland. My learned friend clearly says that's wrong, but in order to reply to that, I would like to refer you to COB, which is in bundle G2, G2A, tab
G2A,
G2A, tab 90.
Disturb that bundle,
I'm sure that's a delight that maybe it's a treat.
Yeah.
The treat I'm going to give you is at page 5576. So this is COD, the Conduct of Business Rules. And I'm not suggesting this point is a killer point. It just reflects my submission as to what dealing really means in this context. If you read COD 6.8, it's quite clear, the whole of 6.8, which is headed Other Dealing Rules, what they mean by dealing, what the context is, which is going out and executing the trades. And that's my primary submission on that. So I'd invite your lordships, perhaps now, if you've got time, just to read 6.8, just to look at the different different examples. It's all in the context of actually executing the trades. And I say...
Well, my lord, this is a different point from the one my learned friend ran before.
No,
he previously said that the dealing, as we exactly as we contend, is the deal between Sarasin-Alpen and the customer, selling the product to the customer.
No.
That deal's complete in the DIFC. He's now saying it's Bank Sarasin then going out and doing trades in the market.
Then he's misunderstood my point. You could look at the transcript. I explained there were two ways of looking at it. If you remember, I said there are two ways of looking at it. This is the first way. The second way is the way that my learned friend has said it. I can pull out my own notes where I've written it out. But I'm sure your lordships understood that when I said that there were two ways of looking at this. And the first way is dealing, which is going out and actually doing the trades. And that's the first way. But the alternative interpretation, which is the interpretation my learned friend is picking up on, which I quite frankly said at the time, there is a second interpretation, is that it's the conclusion of the agreement between the parties, the buying and the selling, that needs to be considered. And then from that, you need to look at where has the agreement been concluded. And we say it's either in Kuwait, where the claimants are located, sign the confirmations, or in Switzerland, when the claimant's acceptance was communicated to the second defendant while the first defendant. Well, the other side say, well, the confirmations of trade were received in the DIFC by D1, and that means it was concluded in the DIFC. But we say that's not correct for the reasons given by Sir Richard Field. It's implicit in the instructions from the first defendant to the second defendant to go ahead and in effect and affect the trade that the claimants have accepted and want the transaction to go ahead. And that instruction to go ahead, and that is only received in Switzerland, and it's only once that's been received in Switzerland that the transaction goes ahead and the instruments are brought. So we have claimants in Kuwait, they go to DIFC, provide the documents, the confirmation of the DIFC, and the communication of that instruction is given to my clients in Switzerland. A great deal of reliance was placed on my learned friend's submissions on Bundle H, tab 138. It may be that we probably don't need to look at that. That's the email, or maybe we should look at that. It's in Bundle H2, page 138. Tab 138. Yes? Is it? 138D, as I understand it.
138.
D.
D.
Yeah, so I've got it now. It's page 6451, 8.
Yeah, okay.
And this is the document that my learned friend took you to. And what we say is all this is an act of the first defendant arranging, it's passing on the instructions of its client to go ahead. And my clients are not going ahead until they've been informed that the claimants had agreed. It's on this topic of dealing as principle, we say, that Adams, we can put this file away, that Adams is important. Because in Adams, one of the key criteria that was being stressed, as well as in the Khorafi and the other cases I referred to, is whether or not the agent within the jurisdiction has the power to contract. And we say it's quite clear that the second defendant had no power to deal, and it had no power to contract. On this, the D1 had no such power. On this aspect, I'd like to take you to the judgment at paragraph 388. And we can see at 388, there are three matters particularly relied upon, which is said to be dealing in investments. And what we say is both 1 and 2 are merely arranging, and 3 is clearly not dealing. That's simply a record of transactions which have already been carried out, namely sending account statements, and that's after the transactions have been done in any event. In any event, on this aspect of dealing as principal, we do rely on the general 2.7.4 exclusion, and perhaps we can look at that in bundle G3. And that's at tab 92, at page 5639. And what we say is the problem with my learned friend's interpretation is it omits the word through. We say it's not merely saying a transaction with, but we say in the judge's finding this is a transaction through, and hence is taken out of dealing as principal. The next aspect is arranging credit or deals in investment. As my learned friend accepted in his submissions, this is not the biggest part of the case. And that if we look at the matters that were relied upon in the judgment of paragraph 380, it's actually relatively limited. It's a relatively limited amount of factors that's set out by the judge. We look at paragraph 380. And you've got my submissions on that, that we say that the marketing material and the account opening forms, etc., they're not they're not us arranging anything. We've also got general 2.9.2, which we say that takes the matter out of general 2.9.1, because we say we granted credit and supplied products as principal. So if we look at general 2.9.2, which is at page 5640, there are excluded from rule 2.9.1 any arrangements for a transaction in which the person making the arrangements is to enter into, whether as principal or agent. And we say, well, the transaction, so far as this is concerned, is the structured notes themselves. We're not, my learned friend, saying, well, you're arranging deals and investments by purchasing the notes in the first place from a third party. But we're not being sued for us purchasing notes from a third party. We're being sued in respect to the sale of those notes by us to the claimants. And if that's what they're going for, that clearly was not in the DIFC. My learned friend raises a point which is not in paragraph 380 of the judgment. They say, well, you're arranging credit in the sense that you tried to help to resolve the issue of the IPO with AKB. But that's really far removed. The party in respect of that was providing credit wasn't us. It was ABK that was providing credit to its own clients. So we say that clearly is not cool. The next one is advising on credit and on financial products and credit. And that when you look at the judgment at paragraph 383, you'll see that only two relatively narrow matters are relied upon by the judge to constitute advising by my client to the claimants. It's the marketing presentations and the structuring of the investments. I'm sure you've got my submissions on that, which I made the other day. Arranging custody, I'm glad my learned friend has now accepted that my clients were in fact providing custody. And we say, they now say that merely because a third party sub-custodian is involved, then we're arranging custody. We say that's not the real world. It's quite clear that all the elements of custody have been provided by my clients. They're safeguarding the investments and they're administering them. If I can answer one of the questions that Sir David Steele the other day, you asked whether we charged custody fees.
That was me.
Oh, was it you, sir? I apologise. That's Sir Steele. If I can answer that, because I think I'm fairly confident I've got the answer right on that. It's bundle J1 at page tab 274. If we start off at 6843, you can see here's the contract note dated the 28th of June for the 8% Rabobank, the right notes, addressed to Mr. Khorafi National Group. And then it says, the securities have been placed in your custody account. And there's no reference there to any custody fee or administration fee taken. Then you can see these notes have been booked. If we look at 275, 6998, my junior says I gave the wrong page number. It's 6863. That's the contract note.
Yeah.
And I was saying you can see this is the purchase of the custody of the securities, and then towards the bottom, above Bank Sarasin, says the securities have been placed in your custody account. And that you turn to the portfolio statements, which are in effect the custody account statements. They start at 275 at 6998. You can see an overview of assets. Then you can see those notes at 7003. And going back to 700, you'll see where the fee, where one would expect to find the fee. It's on page 7000, sorry. It's below there's a separate heading, Administration Consultant Asset Management Fee. And you can see what a fee there would have been. It hasn't been charged, it's 0%. But it's a bit of a convoluted way, but I think that's an answer to your question that there was no separate administration or custody fee charged to the claimants. The next point is the Article 65(5) point. And my learned friend says, well, the only factor is legal advice. Well, I listed in my submissions quite a number of factors why we say we had a reasonable belief And if you look at Mr. Verney's statement, which is the statement I was relying on for those propositions, that does list a number of factors as to why reasonable belief defence applies. So we say it's not limited to the legal advice point. You need to look at all the factors. The next paragraph I'd like to take you through the judgment is paragraph 413. With some reliance has been placed on this in two respects. 413 is in relation to the contract claim. That's the paragraph which is a pretty short paragraph. What they say is, this shows that an advisory contract has been found. That's correct. There was a finding of an advisory contract in a limited Swiss sense. We say that finding is wrong for the reasons I gave the other day. But on the other point that they rely on, which is they're saying, well, on the basis of this, they're asking this court to go back, if we succeed on the main ground, to remit this matter back to the trial judge. Well, the first time there's been any suggestion that this should be remitted back to the trial judge is this afternoon. If you look at their skeleton argument, at paragraph 440, they have asked you to make those findings, which they're now saying they're not inviting you to do. And we say they shouldn't be allowed to have another bite of the cherry in that sense.
Well, just to be clear, if my lords prefer, I am still inviting you to do it, but I'm recognising that you're likely to prefer, if anything, to remit it to the trial judge.
But we say that's a very unsatisfactory way of dealing with things. It's quite clear here. There's been no finding by the judge of what terms are in issue, what terms have been breached, and any loss. It's quite clear that there's been no finding of any breach at all here. And that's reinforced that when you see the order made on the 28th of October 2014 in tab 2 in bundle A, you'll see that at page 179, the judge does make a distinction between the position of the first and second defendants. At paragraph 11, he says, in those circumstances, it was unnecessary to reach final determinations on the contraction tortious claims, but I indicated that at least in relation to the first defendant, I took the view that the contractual claim would have succeeded if it were not for the fact by reason of the breach of the financial services prohibition, the agreement on which that contractual claim was based had to be treated as void. So we said it's quite clear there, the judge is making it clear he did not make any finding of breach of contract by my clients. This now moves into the cost point, and I simply stand by the submissions I made before, but I would stress that in the judgment at paragraph 13, the learned judge did say that that the second defendant was entitled to take a different view of its liability up until the time that the regulatory claim was introduced. So I rely on that in respect of costs. One little matter, which is probably very little in the scheme of things, but is important for my clients to make. My learned friend made a point in relation to a reference when he was taking you through Mr. Walier's evidence, where Mr. Walier was saying that my clients at the relevant time were not rated, and he made the snide comment, well, my learned friend made a great play about what a great institution, and he was saying, well, they're not rated, so they can't be a great institution. As the court's probably well aware, many banks are not rated, and you only become rated when you apply. We were part of the group of Rabobank, which was triple rated, and as a matter of fact, when we did apply, which was 2010, we got an A rating, which is a very high rating given the position of the banks after the financial crisis of 2008, 2009. But I did want to get on the record that we're not a crummy little outfit in Switzerland. This is a very major operation. As regards the points made by my learned friend on the order the order about on the stay of the judgment, I say that this is a point that's been thrown at me with no notice at all. If he wanted to make a point and say that, well, you've got to now pay some huge sum into court, he could have raised that with me. I will, of course, take instructions. I haven't read the embargo judgment on damages, but once I've read it, no doubt, if I'm retained to advise on that part of the case, I will give my client certain advice, and hopefully we can deal with issues like this constructively. And if there's a problem, we can come back to either this court or to Sir John Chadwick. But if I have anything to do with this, there's not going to be any funny games in relation to any issue, and I will deal with my friend in a constructive way. Finally, this is my first appearance in the DIFC court, and I would like to express my appreciation that it's been such a great honour to appear before such an organisation. And I'd like to express an appreciation on behalf of everyone on the legal side of all the help we've had from the staff of the DIFC, who've been unfailingly helpful and polite in this matter. Having picked up this brief at a relatively late stage in this matter, I hope this is not necessarily just a guest appearance, and that I've been of some assistance to this court dealing with the regulatory aspects, which are extremely difficult to construe. And I hope I haven't tested your Lordship's patience too much by that awful experience of having to look at each of these provisions one by one. They are very difficult to construe, but if there are any further specific matters you'd like me to address you on, I'd be very happy to assist.
Well, thank you very much. And in particular, thank you for your observations about the staff here. We are extremely fortunate in having such a good group of people who support the court throughout the year. And I suspect, Mr. Malik, there's quite a lot of work for you there.
Well, I'm normally next door. I'm normally in Oman rather than Dubai.
Now,
I've got the schedules. I can give that to the clerk later, but I've got
yes, I was going to
the schedule of references.
Pick up a few outstanding schedules.
Yes.
First, I remember that there was a list of documents relating to correspondence between the claimant and Sarasin-Alpen, between Sarasin-Alpen and Sarasin, and between Sarasin and the claimant.
Yes.
That's the document you're talking about.
That's the document I wanted to give to the clerk at an appropriate
Thank
moment.
you very much. Well, I'm grateful for that. There was another document that I asked for, which was, and it won't be ready yet, of course, a document, hopefully on one sheet of paper, which shows which witnesses were called in which day. Now, for our purposes, there are one or two things that we need, some of which we already have. It would be desirable to have word versions of the pleadings, the statements, and the transcripts below. Now, we have received, I think, just a short while ago, or maybe this morning, word versions of all the skeletons. Thank you very much for that. But if the pleadings and or the statements and or the transcripts below are in word form, we would like to receive those as well. We would also like, and I suspect that's quite easy, either in electronic form or in electronic form, the regulations. Now, I suspect they can be drawn down from the internet, but it just would make life a little bit more easier if we had COB and GEN and COB2 and so on, all on one stick, or at least in electronic form. We would be grateful for that. We would also like, and before I say what it is, can I thank our transcribers for all the work they've done. We've sat very long hours. We're extremely grateful to you. You've done a wonderful job. You stayed awake, and this is such a valuable contribution to our work. Thank you very much. But perhaps we could be given, and I think the office may already have word form, electronic forms of the transcripts. Some arrangements will be made to print them off into hard copy to the extent that is needed. Lastly, I think I must thank counsel and solicitors for all the work that's gone into this enormous case. I suppose I should thank you. Anyway, you leave us with quite a task, and the task is certainly to some extent lightened by the energy and clarity in which the written and oral submissions have been made. It's a very good example of how this court really does benefit from contributions from distinguished counsel both here and in London. And thank to the solicitors for preparing these bundles, which we shall now take away with us. I've already indicated that you've given us a lot to think about, and these bundles don't land on an empty desk, I'm afraid. We will be as quick as we can, but it will be a considerable period of time. In the meantime, I'm not going to say any more about it. Sir John Chadwick's judgment on quantum will be no doubt issued shortly, and I leave it to the parties to make arrangements for the preparation of an appropriate order, and in the light of that order, to comply with or make provision for the claimants into court. If there is any dispute or controversy, those matters can be brought to the attention of the court here and will be dealt with probably by a member of this court, or at least someone who is sitting as the Court of Appeal, given that the original order was made by Justice Roger Giles, who, in his capacity as a member of the Court of Appeal. Well, I think that's quite enough from me. Thank you very much indeed. I hope you have either a pleasant onward stay here or a safe trip home.
All rise.
Yeah.